Hello guys, it's good afternoon here. Hello, can you hear me?
Yes, sir. Good afternoon.
So how are you doing?
Good, sir. Going on.
Only you have here and tourists came in now. You are there or
Sena Ratna,
Sena from?
Qatar.
Others that you are also there.
Yes, sir.
So how are you today?
Sorry,
How are you today?
I cannot hear
How are
you,
you?
sir.
I said, how are you today?
Doing good, sir. Doing good. Thank you.
There were two other students, right? Hello?
Yeah.
Yes. Yes, what? Who are you, please? Your names and yes, where are you from? Except Galle and Sena.
I'm Nafli from Maldives.
Lucky.
Yeah,
Lucky from
Maldives.
Maldives. Lucky you, Lakmal.
No, I'm Nafli.
Nafli from Maldives. Okay.
Yes. Yeah.
And there was another student, right? There was four students, right? I saw there were four students. Right. You all having a day off today, Sunday.
Yes, sir.
Sir, small request, sir. Can you upload the tudes to the LMS?
Yes, I definitely will do within this week. Yes. In fact, I was supposed to do it before, but to be honest, I had some fever of my family members last week. That was why I was absent. So therefore, I was yes, having some tough time, but all settled now. But I will do during this week.
Sorry to hear that, sir. No issues. Thank you very much, sir.
Also, sir, if possible, sir, can you switch on the camera, sir? We cannot see you.
I'll try. Get the camera here. You can see the board, right?
Yeah, we can see the board, sir.
I can see an icon for the camera.
So if you can go to the Microsoft Teams and you can switch on the camera from there.
Can you see us now? It's an empty class.
Yes, we can see now, sir.
Only myself and three others there. Others are actually having their entering their lunch. Right. Yes. We would love to see you as well. Can you also switch off your camera? It is a position too. Make sure you are in a well dressed, right? Right. Srilanka there, Srilanka there, Ahmad there, Kalna there. Who is Gola?
Gayan.
Yeah, right.
Yes, sir.
Ahmed, Ahmed also from all this. Ahmed, hello.
Yes, sir.
Where are you from?
I am from Maldives.
You work from the Maldives, right? Work from the same place or different place?
I didn't get you, sir. What?
You are with Hasif or separate? Hasif and you the same place?
No, I think Hasif, he's from Qatar, I think.
He's from Qatar, yes. Chandrakant, where are you from?
From New Zealand, sir.
In which part? North Island or South Island?
North Island.
You are there following your studies or
Now I'm working, sir. I already studied.
so what's the time there now?
It's 8:46 p.m.
Right. So our compare set is almost New Zealand compare set. It is almost like a carbon copy.
Yes.
However, I hope now with those countries now they have developed their laws now. Especially something like directors duties, corporate governance, right? Now again, there's a huge gap between our law and your law. Okay. What's the last topic we have now? No. I hope that we have corporation done. Type of complaints done. Promoters, the corporation contract is also discussed. That's what association and promoter. They're doing soon. What time is the morning class? 30. Okay. Start at 1:30, right? The basic time to have a 1 hour lunch break. So we supposed to start 1 o'clock anyway. 1 o'clock. Right, so we have discussed already about the incorporation and related matters, concept of cooperation and different type of company. So do you have any issues about those topics that we have discussed? So today we are going to discuss about the articles of association. That until they join, we have any issues, gray areas, so we can have a discussion. So we discussed about the different type of companies last week before. So now we know that there are different type of companies like limited company, unlimited company, guarantee company, or private public companies, subsidiary and solely companies, offshore companies, overseas companies, all those type of companies being discussed, right? So in New Zealand, what is the name of private limited companies? Any idea? So we use the term PVT, LTD or private limited. Australian use the term PTY or proprietary limited. How is it in New Zealand? Chandrakan,
It's private limited, sir.
PVT, LTD.
Sorry, sir. Private limited.
Private limited or proprietary limited? Is it within bracket PVT or PTY?
PVT.
PVT, then it's private limited. Okay, yes. Australia use PTY, I guess. They use it proprietary limited. American use generally INC, so German people use different terms. Right. Till others come, just let me know how law and society treat private and public companies differently. So we call all of them limited companies. Limited companies can be divided into two as private limited and public limited. So how law differently treat these two types of companies, and how society think of these two types of companies. What can you say?
Utility requirements for public company.
Okay.
Private.
Definitely, right? It is obvious that there are so many statutory requirements for a public companies compared to the private limited companies, right? As an example, mergers, code acquisition, code CSA, rules state act, they are basically not the part of the private limited, but almost all the CSA rules, anyway, not even for the public limited, they are only for the listed company, right? Likewise, almost all those other laws are for the public companies. That is because the law believes public limited companies, so public companies belong to the general public. They are publicly owned. They belong to you and me, the general public of the country. On the other hand, private companies, as name suggests, privately owned. It is a type of business between kinship and friendship. Therefore, law does not involve them, right? Because they are privately owned. Even the capital is faced privately. You cannot issue prospectus. You cannot issue shares and debentures to the general public. They privately raise their capital. Therefore, law does not impose so many rules and regulations. And that's the one way the law treats them. Okay, what else? Members, yes. Okay, good. Yes. What can you say about the members? Exactly, perfectly correct. Yeah. Where for the public companies, law encourage to have number of members to have members as much as you can. But for a private company, no discouraging. So say, have it private, have it between your kinship and friendship. Don't have more than 50 members, right? So law discourage for the private company to have many number of members, whereas for the public companies, law encourage. That's not treat those two companies. Right, what else? Correct, but directors doesn't mean anything. Yes. There are so many things that you can think or talk about the directors in public and private companies. Right. So the public companies, at least there must be two directors, whereas for a private company can one even with the one member, one director. And also in public companies, directors have to retire at the age of 70. The retirement age will not apply to private limited. In private limited, even you can be a director of your company at the age of 100. But in the public company, you have to retire at the age of 7. Right? So that is the, and also directors have so many disclosure requirements in public companies. But in private companies, you don't need to. Right? So that's another way the law treats them separately. You okay about this? So we are just discussing how law treats the private and public companies different. For a public company, there must be a qualified auditor, qualified secretary. For the private companies, especially if the state capital is less than 500,000, any person can act as an auditor or secretary. But yes, there are so many differences in the way the law treats it. Mainly, where public companies can raise funds, issue shares and debentures to the general public, right? It is a must requirement for the public company. For a private company, it is an offense if they issue prospectus, right? So completely different, right? Private companies, it's a wrong, it's an offense to issue prospectus. For a public company, it's a must requirement, right? But yes, you can see that difference. That is how law treats it. So apart from that other requirement I said, for the public companies, even within the companies, there are so many requirements. They have to file a financial statement, group financial statement, right? So disclosure requirement, right? They have to maintain the index register. All of them are mandated for the public company. But for a private company, all of them are optional. Right? Don't need to disclose, at least they don't need to maintain such things. Right? They can done away with the requirement of interest register. Right? If they can pass a unanimous agreement for private limited, they don't need to comply with some requirement of the articles of association. Right? So likewise, there are so many differences that the way the law treats the private and public companies. That is because private companies are privately owned. They does not directly affect the general public society or country. And more than 85% companies are private limited companies. It's a private companies, they become public companies one day. So law also try to regulate all the business all public converting into private limited. So that is why law treats them in a flexible manner. Right. So on the other hand, even the society treats them separate. Right. Even the general public believe that private limited are something like sole proprietorship. Right. For the owners of private limited, you know, the people tell them their names, right? Not the business name. People used to say not site number, every fair right? So because there's a very close relationship between the business and the owners. But in a public company, people don't care. People believe they belong to their public, right? Maybe they are also indirectly. We don't do the Dhamika or someone is controlled by those people. But people's attitude is different, right? So they believe they belong to the general public. Right? So therefore, no one says this is Dhamika company, this is Shaiva company. No one says like that, right? So but private company people believe this belongs to so and so. Right? That is because that ownership generally it's a fundamental principle of company that ownership and management is different, separate. but that is only true to the public companies. In almost 90% private companies, practically there's no difference between the ownership and management. Almost all the owners are board of directors in private investment bank. There's no true separate. Right? So likewise, with the society, treat them separately. Law treat them separately. Right? Likewise, there are differences between each and every type of business. So that's why we discuss different types of business. So that's the first thing before you start a business. You need to select the best business form that is good for you. Right? So that depends on several factors. The nature of your business, the country's regulatory system, your attitude, objectives, your capital requirement, the way the society treats it, right? As I told you, SWIFT was a good example. It was a good example where they knew that people's attitude is different in so people believe guaranteed companies are charities or government owned, right? So therefore, some people get advantage of that. Likewise, people that use an old matters. So accordingly, before you start a business, you can select the very proper business form for your business. Right. So today we will discuss another new topic, articles of association. Articles of association. Before 2007, there were two documents called Articles of Association and Memorandum of Association. When there were two documents called Memorandum and Articles, Memorandum basically controls the affairs between company and third party. As an example, company's object was the part of memorandum. What this company can do, right? What is its capacity, right? What is it formed for? The object. So object was part of memorandum. The stated capital, very important for the banks and other third parties. That was a part of memorandum, right? However, so memorandum controls the affairs between the company and third parties. Therefore, it is really difficult to alter the memorandum of association. On the other hand, internal affairs of a company were controlled by the articles of association. How to pass a resolution, how to appoint directors, what are the rights and liabilities of shareholders. Those internal matters was in the part of articles of association. Therefore, it could be altered. However, even though memorandum was considered as most important document of the company, from 2007, that was done away. Right? So now there's nothing called memorandum of association. There's only one document called articles of association. Therefore, this is probably the most important part of the company law, only second to the Companies Act. Right? So basically it says, right? So section 13 says what could be included in the articles of association. What should be there in the articles of association? Section 13 says, what is there? What does it say? Online students, do you want camera on?
If possible, sir, I think it's good. Otherwise, we cannot.
No, you don't mind maybe camera on, right? Camera is on, okay. So what is there in the articles? What does it say? There's no strict rules, right? You can draft your articles of association. But section 13 says among other articles of association may include object of the company. So even though memorandum is not a part of company law, the main important thing of the memorandum is now a part of articles of association. Therefore, now if you want to have object clause, you can have it in the articles of association. What else? Rights and obligation of the shareholders and management and administration of the company. So among others, those things will be put in the articles of association. Anyway, they were there. Rights and obligation of shareholders, the management, that means how to conduct meetings, how to conduct AGM, EGM, how to appoint directors, right? All those matters are there in the articles of association, right? So, however, to incorporate a company, it is must to file the articles of association. Without this, you cannot incorporate a company. So, articles of association must be signed by the initial members. Initial shareholders have to sign the articles of association. And then, without articles of association, you can't incorporate a company. Right? So, therefore, it is a must document to incorporate a company, articles of association. So, however, the law simplified the requirement of articles given a model article. Right? The first schedule to that is the model articles that can be taken as articles of any limited company. Right? For the limited companies, Act provides the model article. That is carefully, properly drafted. You can take it as it is. In fact, 90% private limited companies take the model articles as it is. So, however, you all have a freedom to alter or amend the articles or draft your own article. But if you draft your own article, you need to get the approval before incorporation is contract. But if you take the model articles, they will straight away approve your article. However, by giving model articles, it helps a lot the incorporation procedure because any person can get their company incorporated having a model article as it is that can be applied for any limited company. Right. We'll see what we're going to discuss on the articles of association. Right. So those are the subtopics that we're going to discuss. Right. What are the articles? The content of the articles we already discussed. Section 13. Right. So application of model articles, the effect of articles, and articles as a statutory contract. Yes. And then we're going to discuss section 17 in detail, which says about the object clause and its effect. And last we will discuss ultra vires rule and the indoor management rule. So this is little complex and lengthy topic. Probably we can discuss this little bit later. So articles, as I told you before, is only second to the company act. Except the company act, the most important document of the company is the articles of association. Right? That was before known as the deed of settlement. Right? It was known as the constitution of the company, the charter of the company. Right? So there are some names. So to incorporate a company, it is must to have a articles of association. So memorandum was done. Right? Now there's no requirement of memorandum of association. But still, it's a part of some countries, including India and UK. Right? But in Sri Lanka, there is no requirement of memorandum of association. One question here is now, object was in the memorandum. Now we don't have a memorandum. Therefore, some people believe, or at least they are in doubt that whether we have object clause. Whether object is part of our company. What do you think? Yes, hopefully you got the point. Next, what can you say? Yes. Object clause is still a part of Sri Lankan company law, right? So many people believe it's not a part of our company law. what we have done is we have done in the memorandum of association. We have also abolished, there's a principle called ultra-virus or beyond the power. But it doesn't mean we have abolished the object. It is still a part of Sri Lankan company law, but it has abolished in some companies. Some private companies we don't need to have it, right? But we can't say it is not a part of our company, right? The best example you already read, right? If you want, you can have a object in the articles. Right? Under section 30, content of the articles, the subject is the object of the contract. But only thing is, it is not mandated. The act does not use shall. It says may, right? So articles may include object. I told you throughout that they use the term shall and may. If they use the shall, it is mandated. If they use the may, it is optional. Therefore, it is an optional requirement that if you want to have object clause, then you can have it. But it is not mandated. So what do you think about object clause? Is it good to have object clause, or is it good not to have object clause for the company? Before 2007, there was a memorandum. In the memorandum, there was object clause. What is most important is when there was object clause, companies could only do what is in the object clause. All others were prohibited. Right? When there was object clause, companies were bound to act within that object. All others were prohibited. That was also considered as a one main difference between the natural person and artificial person. As a natural person, we can do anything unless prohibited by law. Right? We can do anything unless prohibited by law. But as an artificial person, companies can only do what the law permits you to do. All others are prohibited. Say if a company is incorporated to run a say private school or private university, they can only do that. All others are prohibited. Beyond their powers are covered. Therefore, all those agreements are null and void. Because artificial persons could only do what law permitted to do. All others are prohibited. Right? So that was the main difference between the natural person and artificial person. But today there are some issues. So this is done. That because some companies, there's no requirement of object. Therefore, now there are issues now we will get all clear at the end of 2 years, right? Now there are questions whether you can incorporate a company to sell shoes, whether you can sell chocolate. The company will incorporate with the object to sell shoes. So you decide to sell chocolate. Is it perfect? Is it legal? What do you think? Those are the things that we want to get clear. Right. Before 2007, definitely illegal. Beyond there. Because company was only incorporated to sell shoes. Therefore, they should sell shoes. All others are prohibited. Right. We call it beyond their power. In legal term, we call it ultra-virus. Balay Twitter, Balay Galle. Right. So, however, so we discussed that object clause is still a part of Sri Lankan company law. One example is the section 30. You may include the articles in the object in the article. Whereas, how will we create object? We have discussed, I think, before another example, good example. A place where you do need to have object clause. And the type of company. What do you do? Yes. There are some type of companies you can even incorporate without object clause. Yes. Can the companies? Section 32. 33 again especially says about the articles of guarantee contract. Just read section 33. What does it say? Section 33 says about the articles of guarantee contract. What does it say?
Company led by guarantee shall have articles which sets out the object of the company.
Yeah. Guarantee company shall have articles which set out the object of the company. Therefore, for the guarantee company, it's a must. Right? You can't even think of incorporating guarantee company or association not for profit without object clause. If it's a guarantee company, there must be object clause. If it's an association, there must be a useful object clause. Useful object. Right? Therefore, it is a part of our company law. There are some other reasons to show that object clause is a part of Sri Lankan company. As an example, public company, maybe articles may not include the object clause, but it is must requirement for a public company to issue prospectus. I'm sure you might have, you all have seen the prospectus, right? What is the first thing in the prospectus? The object of the company, what they will do within next 5 years, right? So the object is a part of the prospectus. All the public companies are required to issue prospectus. Therefore, object clause is again a part of the public company. And also, there are hundreds of companies registered before 2007. They had the memorandum. They had the object. Right? Now they are considered as a part of articles, but they have object. Right? Therefore, it is a part of our company. The only company that can run without object clause is the private limited companies, but it is not easy because we know more than 8% companies are private limited companies. But yet again, there are some types of private companies, they also have to have an object clause. As an example, if a private limited company is going to incorporate through BOI, then there's a BOI requirement that to mention the object clause. Therefore, all the companies, whether private, public, whatever, if they come through BOI, then there's a BOI requirement that they have to mention the object clause. And also, if the company is related to the insurance and banking, then they have to mention the object clause and they only can run as a PA. And also, if there is a company incorporated to education purpose, including the private school, in such a school and the private universities, then they have to mention the object clause. At least private school cannot have private university. So that they have to incorporate two separate universities. Because under every course two different objects. Right? Therefore, there are some other requirements as well even for the private limited company. Therefore, folks, it is more than enough to justify that object clause is a part of Sri Lankan company. But memorandum is not. Right? We also discussed with the alpha virus tools whether our campaigns are restricted to the object clause. Right? But definitely, object clause is a part of Sri Lankan law. At the same time, you have to understand it is optional for some companies. Okay. So the private limited companies, in fact, you can incorporate without the object clause. My next question was, what is your opinion? Is it good to have object clause, or is it good not to have object clause for the business? Okay. So you all believe it's good not to have a object clause. That's a little bit different way of opinion. Because later I asked this question from the other candidate, So majority of the undergraduates are in the opinion that it's good to have object. Right? In this class, I don't know whether because of the first answer or what. Someone is around you guys don't get on it. So anyway, yeah, I think it is done the way for some reason, right? When there's a business, they should have a freedom to do any business where they can make profit. If they are object of, then obviously they have to, there's a restriction. Right? Especially the modern business, you never know where you can make profit. What you do today, tomorrow is a completely different thing, right? It was not there in the 10, 15, 20 years ago. Right? Nowadays, you never know where they are. Therefore, or the company should have that testimony. Right? Whatever wherever they do, they should have that freedom. Therefore, they have freedom, capacity, power to not be restricted to one or few objectives. They should have that freedom. Therefore, that is recognized by the people who are after complex act. That is why they have made it option. However, I think as a investor, from the point of investors, I feel it is good to have object. For the business, it is good not to have object. Then they can do anything. Right? But for the investors, what do you think? After we like to invest in the company, whatever we prefer, right? But if there's no object cost, we never know what type of business that we have invested. Right? Maybe some Muslim people have invested in the pork business. Because there's no object cost. They can turn their business into anything, right? Therefore, I think for the investors, that's not such a good thing. Right? If there's the investor, then the investors know what type of business they have in this. Right? Sometimes, otherwise, they never ever will invest some type of business. Right? So, in that point, there may be some issues, but for the business point of view, definitely, it is widely recognized better not to restrict the business to one or few objectives, because you never know where you can make money. When I was in UK more than 20 years ago, there were the internet cafes between the KFC and the Lanka. Right? You can see clearly different number, right? They generally sell chicken and chips. Chicken and chips and computers, completely different things, right? If they try to restrict their business, that's what happened, right? So they have more money between their customers to use their internet facilities more than significant. Therefore, nowadays more content. Right? Therefore, business should not be restricted to one more period. Okay? So that is why it has become optional. So, however, it may be a good thing for the investors to know the object of the company, then they have some type of idea what type of business that they have in them. Right. So these are the contents of the articles. So we have already discussed it, right? So among others, articles may include object of the company, rights and obligation of shareholders, and the management and administration of the company, right? If you want to have a look at what should be there in the article, just have a look on Schedule 1. Schedule 1 in the model article, right? So that says the requirements of the what is there in the model article. Or you can, yes, just you can check any of the model articles, they are available, right? You can just take some of the contents. Right? But we can type articles of association of in RCA, mobile dialogue, articles, online, they are available, right? Some of the contents you might see, they have object. Some of the contents you will see, they don't have a object. Dialogue RCA, they have included the object. That is because there are some tax calculations, I think, for the IP and the business. In such a case, they have to incorporate it. Otherwise, they won't get that benefit. Sometimes for some business, the government gives out tax calculation. To be entitled, they have to disclose the object. In such a case, they will disclose to get that benefit. If it was not disclosed, then they are not entitled, even though they do the same business. So that purpose sometimes people include the object clause. Nowadays, I don't think that we delete that concept, isn't it? There's not half of building there. That's the answer. At the end of the lesson, if we have time, we go for some of the articles of association available online. Right? So when you incorporate the company, you have option to adapt your own articles or to get the model articles. Right? So these model articles are only can be recognized for the limited companies. For the guarantee company, you can't get them because for the guarantee company, you have to draft. At least they have to have a object clause without which you cannot incorporate a guarantee company. In the model articles, there is no object clause. So therefore, it is only applicable for limited companies. That is why it says, other than the company limited by guarantee. For the guarantee limited, you can't get the model articles. Or even the same articles you can take and you can modify it. As an example, this article says minimum number of members for a company we can is 2. So with 2 articles, you can make it 10. Likewise, you can modify it. But you can't make it 1. Because access 2, then you can't make it 1, but you can make it 5 or 10. Right. The effect of articles is the articles of association of a company is considered as a contract. Right. It is considered as a contract. It's a contract between company and shareholders. And also it is a contract between shareholders and shareholders. Therefore, if there is a breach or break of articles, then one party can sue against other party for breach of contract and can get remedies if the party affects. Right, so however, articles effect as a contract only as a member of the company, not in any other capacity. Only as a capacity of a member, only as a capacity of a shareholder. So outsiders cannot sue against the company for breach or break of articles. Right? There's no contract between company and outsiders, right? It's something like treaty of contract, right? Even though you affected, even though you are the beneficiary, when there's a contract, only the parties to the contract are bound by the terms of and condition of that contract, right? Third parties have no rights or liabilities under the contract. Say as an example, if A and B enter into the contract to give 10,000 per month to C. So contract is between A and B, right? Beneficiary is C. Our contract is to give 10,000 per month to C. After 6 months, we stop. Now C file a case. Is it possible? No, he cannot file a case because he is not a party to the contract. A can sue against B, B can sue against A. Even though C is a beneficiary, he cannot sue against any of us because in contract there's something called treaty of contract. I don't know whether it's right. Treaty of contract. Only the parties to the contract have rights and liabilities under that contract. Third parties have no any rights or responsibilities or liabilities, even though they are beneficiaries. Likewise, articles is a contract between company and shareholders or between shareholders or shareholders only as a capacity of member, not in any other professional capacity or not for the third party. Therefore, third parties can sue against the company for breach of contract, even though it goes against the articles of association. Company can sue, members can sue. even in this case, also says that even though you are a member, you can't sue against the company in any other capacity. In this case, there was a company. The company solicitor, company secretary, was also they are in the company. In the articles, there was a clause that all the litigation of the company should be given to the company secretary. All the company litigation should be given to the company secretary. At one point, some of the cases were sent to the outside law. Then the company secretary, company solicitor filed a case against the company for breach of the articles of association. Right? Here there was a question whether he can sue. What do you think? Article says all the company cases litigation should be given to the company secretary. At one point, some of the cases were given to outside lawyers. Then this man filed it. According to articles, they should be given to police. Yeah, for the return fee, yeah, then those guys. One of them came to the non here. Can all you appear before the court? Before the court, the only person who can represent himself at a reception. No, no one else. You can represent yourself, or the only other person according to the constitution is the lawyer who can represent you before. Therefore, the litigations for cases given to the company solicitor as a capacity of a solicitor, not as a capacity of a member. Right? Therefore, court decided there's no article, this is not a contract between the solicitor and the company. Right? It is all. There's only contract as a member of the company. But cases given to him not as a member but as a lawyer. Therefore, court decided in a professional capacity it's not a contract. So therefore, you can't sue against the contract of people. Because they were given to him as a person, not as a member of the company. As a professional capacity, it's not the contract between the company and the member. So therefore, articles is a contract, but only as a capacity of a member. So, articles of association is the contract. It's the contract between company and shareholders, and also between shareholders and shareholders, but only as a member. Right? So, apart from that, there may be some other contract between company and member. Because we already well known now, company is a separate person, shareholders are separate. Therefore, those shareholders can be a debtor, creditor, supplier, employee of the company. There may be so many other contracts between company and shareholders, there's nothing wrong with that. Then what are the difference between those other contracts and articles of association? They are also contract, this is also that. The difference between the articles of association and other different types of company contract, articles of association is considered as a statutory contract. This is considered as a statutory contract. And if there's a breach or break of articles of association, generally they are decided according to the principles of company, not according to the principles of contract. Right? All other contracts, when there are issues, they are decided according to the principles of contract. The company law government employment contract, supply contract, so they are settled by general force according to the principles of general contract. But whenever there is issue related to the articles, that is settled or decided according to the principles of company, not according to the principles of contract. So that's the difference between the articles as a contract and other contract because they may have so many other shareholder agreement between the company and shareholder. Right. Then article is a contract. All the shareholders are bound by the articles of association. Right. So they have to comply with that. Even when they are saying any share issue or whatever, they also become a part of it. Therefore, shareholders are bound by that terms and conditions as well. Right. However, there are two exceptions to this. So it's not a heavy thing. There are flexibility, there are exceptions. Right. So there are two exceptions. One exception is that notwithstanding anything to the control in the aspects of the company, shareholders should not be bound by a resolution also in its article, or required to acquire or hold more shares in the company where that resolution or the holding of those shares will increase the liability of the shareholder to the company. Yes. Therefore, company cannot increase the liability of share. Company cannot increase the liability of share. If the company passes a resolution that to buy more shares and to get more liability from the company, then in such a case, if that shareholder has not voted in favor of that resolution, then they are not bound by that resolution. So therefore, company simply cannot increase the liability of shareholders. Original articles, they are bound. But if the company alters the articles, especially to bound by resolution also in its articles, so required to acquire or hold more shares, where that resolution or the holding of those shares increase the liability of shareholders. Then those shareholders are not liable by those altered or amended articles unless if they have not given their written consent. Therefore, shareholders are not liable for the amended article. But if they have voted in favor of that resolution, then they will be liable. If not, they are not liable. Right. Now we all discussed about the object source, some of the issues. Right. Now we know that object source is a part of Sri Lankan law. At the same time, there may be some companies without any object. So now we will discuss what is the effect of object source, if any. Right. So now it is plain. In Sri Lanka, some companies they are mainly objects, some companies they are may not be any object. So if there are no objects, there will be no issues at all. When there's an object, so we discuss what is the effect of that object. Before 2007, when there was object clause, companies' power and capacity was clearly restricted. They only could do that business. Anything beyond that object clause were considered as beyond company's power, beyond company's capacity. In legal terms, it is known as ultra-virus contract. Ultra-virus contract, beyond the power. We can ultra-virus, right? So, ultra beyond power. Company බලෙන් පිටත න්‍යාය කියලා කියන්නේ. So when there was object clause before 2007, company's power and capacity were restricted to that object. If they have done anything beyond that object clause, company has no power and capacity. They were considered as null and void. Right? So this is decided with this case, as per case, as per railway carriages and company limited versus Ritchie. Right? In this case, this is a very old English case. The fact of this case, there was a company, it was incorporated to make, hire, lend, lease, railway wagons and carriage. 40-50 हजार the company had. That was the object of the company. One day, this company entered into the contract with the English company. They entered into the contract with the Belgian company to make a railway line. Kochi Petri has a Nagatama Adamana Paramarte, about that Kochi Parada. So it was approved by a resolution as by Shah. Now it was started. To some extent, it is done. However, two shareholders filed a case. So they are voted against the resolution. So their argument was, company has no power, capacity, authority to make a railway line. Therefore, this contract, this transaction was null and void. No legal. So what do you think? Other than being in that moment. But however, at that time, almost all the companies all around the world had the memorandum. 18 calendar December. So they had object clause. Right. So in this case, court also was of the opinion that no company was incorporated to make railway line. That's what the judge's opinion was. There was a company. It was incorporated to make railway lines and carriage. So they have to do that. Right. Now they have doing some other business, making railway lines. So the company's argument was, it was ratified by the company. Because company has passed a resolution. Therefore, company has approved. Company has ratified. If you remember the agency law, agency by ratification. Right? Pasti anumata kilo teka munidama walangu yusuma pada. Right? So principal can ratify the contract entered into by agent. So the company argued that as shareholders have passed a resolution, it is approved by the shareholder. Therefore, it is ratified. Now there's a ratification, agency by ratification. Therefore, this contract was valid. Right? I don't know how many of you remember the agency law. But the commercial level too, the agency. Exemption. Commercial broker and a long time ago. Corporate exempt and commercial exempt. You know, a kernel where mother one has a commanding affair 2 weeks in mother. Then the Indian take the one that 2 weeks of mother have a family. The Gideon of the Labayam or Gisa legally mother. But they got the Manaya for mother. Samana is mother, they are known with name. Right. In this case, anyway, the court decided that this is the old case anyway, right? No application to legislate is possible. At that time, they have a object clause, they have a memorandum. Therefore, companies were expected to act within the object clause. So in this case, court decided that it is true that company has ratified the contract. However, according to the principles of agency law, to make a valid ratification, there are some requirements. Ratification the requirement. Right? One of those requirements is that both illegal contract cannot be ratified. බලයක් නැතිව මොනවද කරන්න බෑ. කම්පැනිට බෑ රේල්වේ ලයින් එකක් හදන්න. ඒක කම්පැනි නැති දෙයක්. ඒක ෆෝර්ජ් එකක් ඉලීගල්. Right? Such contract cannot be ratified. Even though ratified, ratification was not ratified. Therefore, court decided this type of contract cannot be ratified because no company was incorporated to make railway lines. So how can you ratify? Right? Therefore, in this case, court was of the opinion that before a third party enters into the contract with the companies, it's the responsibility of the third party to check about their memorandum of association, which was a public document available in the company's house for general public. So the law expected for the general public to look at those requirements, whether companies have a capacity to enter into such type of contract. That was the court's opinion in that case. Therefore, they have not checked about the object clause, whether they have such a power, right? So therefore, court decided this type of contract cannot be ratified, even though ratified, it is not valid. Therefore, this contract was declared as beyond the company's power. It was decided as an ultra-virus contract. Such contract cannot be ratified. So that was the law about the object clause. So this is known as the doctrine of ultra-virus, beyond the powers. Right? So, however, what do you feel about the third parties who enter into the contract with this company and done their contract halfway over? It's a very poor situation, right? Even though the judges say that you are expected to go to the check and memorandum and object clause and all, is it practically happen? Whether people will check the company's articles or memorandum? Even though they check, is it clear that they will understand those legal language? Sometimes. So you cannot really expect that. Right? So, however, that was the law. That was the law. There was a memorandum. In the memorandum, there was an object clause, and the company's power and capacity was limited to that object clause. All others were regarded as a ultra-virus. Thereafter, so many companies started to have several object clause. ඒකේ පස්සේ කරේ තමයි main object කියලා එකක් දානවා ancillary help එකක් කරලා කියලා තාලා තව object දානවා 10ක් to cover almost everything, right? That is also like, you know, දැන් ඔරේ කරනවා වගේ නේද ළඟින් හිටන හැම object එකම දානවා. In that way they try to cover those type of illegal contract. So that was the trend until the law was changed. However, from 2007, so this was understood by the developed countries like New Zealand, Canada, Singapore, right? They understood that this is not the way to run the business. You cannot expect the third parties to go to the registrar general office and check for the memorandum and object clause. Therefore, in those countries, they really relaxed the law. Especially they changed the laws to protect the third parties who enter into the contract with the company in good faith. So following that new trend, in 2007, when we passed the Companies Act, we also abolished the doctrine of ultra-virus. Now in Sri Lanka, there's nothing called beyond the law. Right? So, however, it is very nicely done in Sri Lanka. Right? We'll try to understand it, maybe in little complex, but I hope we have done it very smart. It is done such a smart way, some people even cannot understand whether we really abolish it. So honestly, we have abolished it. Yes. But it is done in a very good manner. Right? So it is done with section 17. So we try to understand how Sri Lanka has done it and what is the effect of object growth in Sri Lanka when there is a object. So clearly there is no application of this case anymore because it is outdated. No application in Sri Lanka. So we see our law, right? So the relevant section is section 17. So now probably it is now clear that companies no longer has to state the object growth. At least limited companies are no longer required to have the object growth. You can incorporate a limited company without any object. However, they also have option to have object growth. Right? Now this section explains you what is the effect when there is object growth. If the company wants, it can set out the object growth. Right? So this section says when there is object growth, what is the effect? So this section says when a company is incorporated to sell sugar, what will happen if we sell chocolate? What do you think? Should it be permitted? Or what will happen if they do? The company and object here, right? Then because there's no leather or whatever. Now you sell chocolate completely. What will happen to those new business, new country? No way. No way. Yes. There are so many countries. Take option. Stop. Monavid, the question chapter. Not permanent. Monavid. Not permanent. Just say 17 for the fingers or something like that. Probably you may need to read this section 3-4 times, right? When you read this first time, maybe like Greek, read it again. Then we will be like French. That time you will get it as English. That first time in English again. Online people, I hope you have a copy of the Companies Act.
Yes, sir, we have.
Just try to read and understand what the section 17 says. So it says all about object growth and effect of object growth. So up here, first read the section 17(1). This lengthy section, right? So section 17(1) says, if the article set out the objective of the company, it should be deemed to be a restriction in carrying on any business or activity that is not within those objects. So it implies that if there is object source, so it is always good to act within that object. It will be the case if the company was incorporated to sell shoes, do shoe business. That's what it says. It is going to be a restriction. Carrying on any business outside that object. But it doesn't, it's not that much clear to whom it is a restriction and so on. So it says deemed to be a restriction. Now let's see what the section 72 says. Section 17(1) says, if there's object clause, they have to act within that object. Anything outside that object is considered as a restriction. Deemed to be a restriction. So section 17(2). However, however, even though the company has such restriction by the articles, the capacity and powers of the company should not be affected by such restriction. If there's object clause, is deemed to be a restriction according to section 71. But section 17 says, even though there is such a restriction provided by the object clause, it is not a restriction for the company's power and capacity. Then again, we can look at section 2. Company has the power and capacity to do any business. Company is just like a person like you and me. Therefore, those object clause is not a restriction for the power and capacity of the company. Then it looks like again, company can do anything. Then company can sell chocolate according to this section. Next. Even this due to be a restriction, company can do. It does not affect the power and capacity of a company. I think there's a further explanation. Next. And further explanation. How can you cannot get you? It almost looks like company can do anything. Yes. An act of the company or contract or other obligation entered into by the company and the transfer of property by or to the company shall not be invalid. Shall not be invalid. By reason only of the fact that it is done in contravention of such restriction. Therefore, even though there is a restriction, even though there is a object clause, this company can engage to any contract, any obligation, any transfer property. Right? They should not be invalid just because of it is done in contravention of the object. We further say something can do any business. Shall not. Cannot be again. Cannot be invalid. That shall be clear to something. No, we are on the we know we are on I don't know. You make a sense, and give me immunity. So it says company can enter into any contract. Whatever the object clause says, is still they are not invalid. Even though company is the contract, it is not provided by the object. So what are money people? So here, the law recognizes that object clause is not a suitable vehicle to control the business. Sometimes should be given the freedom to do any business. Sometimes more similar to a human being. Their power capacity should not be restricted to one or few object clause. So compare almost like a human being today, right? So they can do anything. So you don't need to bother when you enter the contract with the company, right? So no longer required to check the object clause and so on, right? Because company can enter into any contract. Now let's see the third one as a little more complex. So हो गया 17(1) says if there's object clause, it is due to be a restriction. So it says it is always advisable to act within the object clause. But section 17(2) says it is not a restriction for the company's power and capacity. So whatever the contract obligation or whatever accepted by the company should not be invalid, even though it is done in contravention of the object. But again, section 17(2) says even though the company can do anything, even though it's not a authorized contract, right? Section 17(3) says it does not, how does it say? Nothing in subsection 2 should affect the ability of a shareholder or object of a company to file a case against the company under section 2(1) and 33. So under one section, shareholders are given the right to file a case if the company acts in contravention of the object. Okay, I'm not telling you this story on the under one section, one special section, section 233, right? Companies incorporated to sell shoes. Now they sell chocolate. Then a shareholder can file a case under section 233 against the new business. That's a one right given to the shareholder. That is why it deemed to be a restriction. That is why it is abolished in the narrow sense. Even though there's nothing called otherwise, it doesn't mean that they can do anything. Still shareholders can challenge it. But not very limited man. Only under one section. Section 233. It is restraining order. You can also have a look. What does it say? Section 233. We're going to learn them separately anyway. Just look at section 233. It says about the restraining orders. Restraining order. Under this section, shareholders can file a case against the company to restrain the new business. If the company acts in contravention of the company's act and articles, if the company violates the company's act and articles, it is a serious thing, right? In such a case, shareholders can file a case against the company not to do that, right? So, object clause is in the articles, right? If the two companies start chocolate business, it is in violation of the articles, right? Then the shareholder can file a case against the company not to enter into the new business. So that is good enough, right? You get the more understanding if you can read section 233, is it? Restraining orders? 233(4). Read that one as it. For the deed, for the deed. What does it say? If the chocolate business has already been started, then court cannot order against the company. Right? If the chocolate business has already been started, then the court cannot order against the company even under this section. That means company can again do anything. Right? Because if it is already started, it affects the third party. That is not fair. Right? So it is good. Already started, then company, then court cannot order against the company because it definitely affects the third party. So third party should not be affected because of the fault of the company. Therefore, court cannot order against any third party if the contract is already concluded. However, if it is not concluded, if it is only in the very beginning, then it will not affect any party, any third party. Then you can challenge it. So that is also good enough. Ne? So business people, they should be aware of the companies too. So if they can challenge it, then court can order or they can restrain it. Right? But if it is started, then it affects the third party, then the court cannot order against the third. But before starting new business, before go for a new contract, then you can challenge it, then court can order to restrain such things. So that is why I said our control is very good now, right? In one side, it says, don't violate your own heart because you draft. Right? So basically, articles of association drafted by the directors. Therefore, you cannot violate whatever drafted used by yourself. Right? But if it affects third parties, then they should not be affected by your fault. And companies also are thus. So its power and capacity should not be affected. It can do anything. So it's very narrow sense it is restricted and very narrow it is abolished. Right? So again, Lama it says, nothing in subsection 2 should affect the liability of the director of the company for what does it say? In violation of the articles of association under section 188. Then again, shareholders can file a case under section 188, and they also can file a case under section 233. Under section 233, anyway, if it is already been completed, there will be no penalty. But under section 188, again, shareholders can file a case against the directors. What is section 188? Director duty on section 186 investment directors are duty. So 188 is directors duty to comply with the Companies Act and the Articles of Association. Only section here, directors duty. It's a main duty of the directors as a directors of the company, they are under the duty to comply with the Companies Act and the Articles of Association. Right? If the article says this company is formed to sell shoes, then it's the duty of directors to sell shoes. Right? Because it is drafted by themselves. Right? So they should not be given a chance to violate their own. Right? Directors should be well aware of the object of the company. They are the rules drafted by themselves. Then they themselves should not be permitted to violate their own laws. So that is why, if they don't comply with the Articles of Association, then it is a breach of their duty. Therefore, a shareholder can file a case against the directors if they act against the article, against the object clause, because object clause is a part of article. Then is the company, is the shoe company sell chocolate? Who's liable? Company is not liable. Then who is liable? Ultimately, directors are liable. You can sue the directors for breach of their duties. Therefore, directors are liable to be, right? Before 2007, the company was liable. Company had no such power and capacity. The contract was declared null and void. But today, there's nothing wrong with the company contract. The contract is good, but directors may be liable for breach of their duty. So that is the law in Sri Lanka. So from this, a good law, right? Because it's the directors who make or draft that. So they can violate their law. If they do, they are liable for breach of their duty. Even there was one case in Sri Lanka for after this 2007. In that case, Justice Masud said very nice statement. He made a statement that now there's nothing in Sri Lanka called doctrine of ultraviolence. Ultraviolence is content on. But what is operated in Sri Lanka is doctrine of intraviolence. Balin Pitana Bale Atulania company liable, directors are liable. Within the company, directors may be liable if they breach the Articles of Association object. Two companies chocolate because directors are liable. So within the company, directors are liable. So that is our law today, right? So companies can do anything. Because honestly, you can't expect the third party to read the object clause, to read the articles, right? You can't expect that, right? Therefore, they are protected. Right? Is it clear? That is the thing. This is one of the main difference between the law 2007 and 2. Before 2007, there was the memorandum, there was the object clause. Companies only can act within that object, all others were null and void. But today, completely different. Nothing called null and void, nothing called ultraviolence. The company can enter into any contract. But within the contract, directors may be liable. And also, shareholders can file a case against the company, but before completion of the task. If it only be completed, then they cannot sue against the company. Right? So this is what we can say. Section 17(3) does not mean that the object clause or restriction on corporate power has no effect. Object clause से किसी effect का नहीं किया क्या नहीं वो तो directors are liable नहीं this object clause का और नहीं किया ना बेरा है tribunal ते हम directors ने नहीं लाया. So while third party need not be disadvantaged when a company breach its own constitution, when the company breach their own constitution, so third party should not be affected. Like that Belgium company. Right? Belgium company affected. So they should be protected. So third parties can enter the contract in good faith, so they are protected. The contract is good. There's nothing called otherwise contract. contract with then, right? The possibility remains that person within the company will. Company actually liable in the floor. Directors liable in the floor. Have I compared the third party, third person, right? And also, Lama, even though we say that we have no object clause, directors can enter into any contract, right? You don't need to think that even though we have done away with the memorandum clause, memorandum of association, even though there's no object clause, it is nicely balanced by some other section of the contract. One best example is section 185. That's one important section for you people, auditors and accountants. Section 185 is about the major transaction. One of the major transactions that can be changed. The company cannot enter into major transaction. The majority directors cannot enter into major transaction. There is a procedure to enter into a major transaction. Section 185(2) defines what is a major transaction. Section 185(2) defines what is a major transaction. You have to make sure that transaction you sign or whatever are not a major transaction. So major transaction according to section 185 A, B, C. According to section 185(2) A, B, C, major transaction is a transaction which has the effect of more than 50% of the company's assets. It may be a sale or purchase. Right? If company buys something, purchase something, acquire something, or sell something, right? Dispose something, right? Which has the effect of more than 50% of the assets of the company, it is a major transaction. It is a major transaction. A, B, C, some financial interpret company is the Vatanman, see the Panata Vada, Vatna, done Vipunada, a some other contract, yet other contract, it is a major transaction. Then company cannot enter into such a contract. The company can only enter into such a contract according to section 185(1). 185(1) will give a the directors are up there, simple majority up there. Right? If company wants to get such transaction, 75% of shareholders must agree. And they have to pass a special resolution. Majority, simple majority. Directors are up there. In many companies, 57% belong some other parties of families. But 75% is unlike. Right? So to enter the major transaction, 75% shareholders must agree. Special resolution can a resolution passed by more than 75% of voting right. Take a whole example there with 15 days prior notice. Right? In my special resolution I passed by last. Pahala can make a minimum and then here 75% agree. 51% online. Therefore, to enter the major transaction, it has to be approved by 75% of share. Even if I'm this number it was even at that, 100%. That's a major transaction. It's important for you, right? Well, compare to what you can see the parameter. Both resolution right? Definition you have to have a resolution passed by the shareholders special resolution. Both take a board special resolution sometimes we should like one of my bank bought the land in the from the foreigner who is in board, right? Then he was the only shareholder, right? So he had to pass several resolutions. One of them was the special resolution because it was a major transaction. That house was the only property that company had. Therefore, as a shareholder, he had to pass a special resolution. As a company, he had to pass a resolution authorizing himself to execute the deal. Right? Likewise, as a company, as a director, as a shareholder, same person passed himself. They were required to have a proper transaction. Even though there's only one person, still you have to comply with your requirement. Therefore, you have to be extremely careful when you as auditor to accountant because some of the secretaries are not aware of the they will board resolutions to go right? It's only you know whether it's a major transaction or not to your company. Right? It's a major transaction, board cannot. Right? However, I wanted not what I discussed, I wanted you to have a look section 185 2B. It defines major transaction in equivalent manner. Major transaction act here. ABC will remain financial. BA to only get. If the company is later on business, it is also a major transaction. There is the shoe company is a total business, it is a major transaction. Right? Then directors cannot be. Right? Then directors cannot be. That is why I said even though you say that there's no object clause, it is nicely controlled. Right? It doesn't mean that directors can do anything. Right? So if they change the nature of business, if shoe company start a chocolate business, it is a major transaction. Then 75% shareholders must agree for that. Then only they can go for a chocolate business. In such a case, they can. That is fair enough anyway, because clear majority is with this. Then they can start chocolate business. Even though it's not provided by the object. Right? So that is how company can enter into major transaction. That is the effect of the object. Right? However, change of object is defined as a major transaction. For someone in management, if the company change this nature of business, it is defined as a major transaction. So that's a very good restriction on the wide powers of director. Right? Directors have powers restricted. Right? Therefore, in Sri Lanka, it is true that we have abolished the doctrine of ultraviolence, principles of beyond the powers. Balen Pite Katiaran, Monoakilva take a company by the company has the power and capacity to enter into any contract. Right? However, it is done in very narrow sense, making directors within the contract are still liable. Right? Therefore, if the company enters into the contract for any other obligation which is not provided by the object clause, then within the company, directors may be liable if they have not done it with the passing of the special resolution. Right? And therefore, the ultraviolence rule in Sri Lanka is still operate internally. That is why Justice Masuk says we have a intraviolence rule. Right? So the reason for having this type of law in Sri Lanka, right, to strike a balance between the interests of the company members and third parties. Right? You can see the members of the company's interests are also safeguarded. They can sue against the company before they enter the new contract. Even after they started, they can sue against the director. Therefore, the members are also protected. At the same time, third parties are also protected because there's nothing called ultraviolence. Without any fear, third parties can enter into the contract with the company. Right? Therefore, both are nicely balanced. And also to ensure that the company does not suffer from any limitation upon its legal capacity. From the date of incorporation, now companies are also very similar to a human being. They also can do anything, even though it's not provided by the architect or the object clause, still such contracts keep valid. Right? So third parties are also protected. Companies also have a power and capacity to do any business. Therefore, nowadays we can say that the companies are different, almost similar to a natural person. They also can do, right? Not limited to the object clause. They also can do what they were law permitted to do. Right? And also to recognize that the object clause is not a suitable vehicle to control the business activity. Right? When you do business, you never know where you can make profit. Where is the evolution? When there's object clause, you are restricted to that. There's no failure. Directors cannot enter into any risk. They have to check whether this is within the powers or not. But when you do business, you can't do business in that case. You should have a full freedom, right? So to enter any business or to take any risk. Therefore, now there's nothing called alpha virus. Then the board or the company has a full freedom to take any risk or to enter into any contract. Therefore, they can make any business where they can make profit for their shareholders. Right? So that's another reason to recognize that the object clause is not the suitable vehicle to control the business activities. So that is why we have abolished the rule of doctrine of alpha virus, but protecting the right of the shareholders and the third party. So that is the effect of object clause in Sri Lanka, right? So therefore, we can see a really simply can say there is a part of our document whether it is effect, whether it is no effect, right? So you have to take all those things and then take the idea what is the role, what is the effect of object clause in Sri Lankan law. Probably it's very smart, right? It's very nicely done in Sri Lankan company law. Yes, role of the object. Right. Thank you. Right. That's enough for the object clause. Any issues? Any questions? Anybody? You are not the clause. Sometimes you also have to go to the real architect and all to get the very clear idea, right? Architect or one other clear thing we have here, but when we contest act is the main law, right? Sometimes with the articles of association, there may be some other restriction there. Articles is not restriction than one, right? However, the main thing is the contest act. And also, probably the only company in Sri Lanka that can run without object clause is the private limited companies if they don't come to the GUI or if they don't have a special object like education. So even some object clause are going to run by and committing people. Come on, ever in the non Congress or idea now, even tax section will be able to object clause that. It's object clauses among the consider theme. Partner working out is a command. You will not partner object clause your data. Tax section and there's no reason to have object. Somehow kind of killer case. Other chocolate companies are like a particular one, but in a buying don't neck. When tax section like one kilo dragon, but still you can understand it. Somehow got the demon model to Salayama, they can sit for Chagana, so that you want to do not become. I mean, all the color object was the look at the road net, A object B paradigm, emotive. If law does not require you to have object clause, you don't need to have object clause. There's no object clause, he does not told. Then that company can do it. Somehow काम ही पाएंगे object करने को चलने का दान जाएगा. Somehow bank को भी ना maybe paramat. आपने भी किया उल्टे बताने के लिए मुझे तालु हो रहे right it is established in 2007 तुम्हारा फार्मर डायरेक्ट करता है कि अनिवार्य तो कंपनी है पुनः ऑब्जेक्ट को स्टेटमेंट करो बिफोर 2007 ये तो the farmer has to done everything now make halna को make farmer तो को make object किया ये वाला चीज़ है हमें कंपनी इनकॉर्पोरेट कर ऑटोमेट कर देगा और क्लाइंट का लेकिन ऑकली नहीं उसको समानता दान में एक लोग आए लोग इसका बात किया निकल के कराने के लिए हो गया मॉडल लाके ये ना है so private business content you can incorporate without any object and that's the best way to incorporate your content without the object then there's no restriction at all that company can do anything I'll take a content there's nothing wrong with that compared to person just like you I will do a like competitor so there's nothing wrong with that right okay enjoy your break and then we'll question पर the company लोग आए कराने के लिए इधर नहीं वाला company लोग कराने के लिए क्या करते हैं आगे किधर एक ही टू एक्ट के हम करते हैं कराने के लिए रीजन करते हैं हम ये एक्ट के मतलब कितना भी कराते हैं Right, shall we continue? Right. So now we know what is the article of association of a company, right? So articles of association of company is the one document which is must to incorporate the company, and as there's no memorandum of association, this has become the most important document of the company, second to the Companies Act. So generally in the articles of association, you can include anything, right? Almost all the internal management of the company, and now also object clause is also a part of the articles of association. So basically, the object clause, the rights and obligation of the shareholders, and the management and administration of the company are main part of the articles of association. So articles of association is act as a contract. It's a contract between company and shareholders, and also a contract as a between shareholders and shareholders, but only as a capacity of member. As a member, it's just break of articles of association. Any effective party can file a case against the other party and can get compensation. So then we also discussed about the object clause and effect of object clause. So in Sri Lanka, the object clause is no longer a mandatory requirement to exist for the legal term. However, companies have option to have an object clause. If there's no object clause, such companies can do any business. There's an object clause. Then we discuss about the effects of such object clause. So basically, still it is not the it does not affect the company's power and capacity. So clearly we have abolished what is called the doctrine of ultraviolence. That means today companies can enter into any contract, and those contracts are considered as good valid contracts. However, it doesn't mean that the board of directors can do anything. Right? If we are against the law, if we are against the major transaction, or if the contract, when there is object clause, if company act beyond or against object clause, then there are some remedies available for a shareholder or director. Especially there's the one remedy, right, available for the shareholders or directors under section 233 restriction order. Under restriction order, the restraining order. Under restraining order, if a company or directors act in contravention of the object clause, the shareholders have given a limited right to file a case against the company. And also, under section 188, the shareholders have given right to sue against the directors when they act against the object clause. Subject to those two sections, companies can enter into any contract, and they are considered as a good valid contract. So we also discussed why these laws were industry basically. The main point to abolish the doctrine of ultraviolence is to strike a balance between the shareholders' rights and the rights of the third party. So it makes good balance, like a balance between the members and the third party. It should not be affected for the act of the company. And also, the law recognizes that it is not, the object course is not a good vehicle to control the business. Right. So therefore now the ultraviolet rule is abolished. There's another rule called indoor management rule. Right. Indoor management rule. So indoor management rule means if I explain it to the case, right? So this is also known as the track one, right? Because this is the case Royal British Bank versus track one. Very old case decided in 1850. Right? So as the Ashbury case that we discussed about the ultraviolet rule, that is abolished. Now there's nothing called ultraviolet. But this tool is still operating. Right? Even though it is decided in 1856, still this is a part of our law. This rule decided in that one case is also known as the internal management rule or indoor management rule. The fact of this case, there was a company. At that time, all case, articles of association were known as the legal settlement. Okay. Right. So in this case, company's articles of association, as they know legal settlement, authorized its directors to borrow money. Authorized its directors to borrow money. Subject to that the company pass a holding resolution. Right. Therefore, what is important is whether the directors have that power. That's what. So they had. However, the company's internal matters required to pass a holding resolution to go for a loan facility. In one case, the two directors bought a loan package from a Royal British Bank. However, it was not authorized by the holding resolution. As company failed to repay this loan amount, the bank filed a case against the company. Company argued that we have not authorized those directors to enter into the trading contract, financial contract, because we have not passed the holding resolution. Therefore, banks take no liability. The bank has to file a case against the two directors and get it personally from the director. Company won't pay because company is not liable because we have not authorized, we have not passed the holding resolution. According to articles, they have a power to borrow money, but resolution we pass. It was a holding resolution. So what do you think? This is the law today. So just let me know who's liable to pay. Bank or director. You don't think they're liable to any company. Company go away, it's no finance. So volunteer money to money again. That's the thing to come on. Because company is a little fiction. What do you think? Who should be liable? Company or director? When we go through the article, it says directors have authority to borrow money. Provided that it has to be approved by a holding resolution. So they took the loan facility, but no holding resolution was passed. That was a question. That is why company rejected paying the bank. So company again, we have to get it from the director because we have not. Tapi bank saya pun. Bank berada di mana? Itu. Tapi bank pun ada discount ni. Bank pun tahu ada solusi yang pas sekarang. Bank asal dia customers, he take the letter example. Then they will type it with their picture. So this is not. So that's why this guy there. You don't समाधान देखो केला. ये तो नहीं लगता है. You don't like a pastor and you don't like. You must be asked the doctor to find and to bless you. That's really cool. There is no such questions at all. You know, restaurant may pass me in hand. There's a question of pastor. I don't know. But there is a case 18. So again, no, like that. But yeah, the best actor is the one you see all this section and come tell them. Other than that, you can't make it. We can follow some of the so someone talked to them. Kalau produk natural level saya waktu itu tiru dan peluang tentang ada yang kita penggotian ni kiam. I don't know whether it was legal or not. To understand the purpose. Second, please come in on the working place. Then must have all on the way. You cannot understand something. Maybe what's the idea that you get? But how many people say? And you get and get the Bamam looking young man. Sometimes call it 1 kilo, sometimes I will give it. But it doesn't do. Ask the person now, I just going to make that. If a person actually asks the complaint, if the funds can be used as the authority, this is a place that. So, someone will this person can be used. Or what is mechanically called, other than this process plan. You can see that the doctor can see that he has been for the respect that the person will give this man has the authority to do it. This is a doctor plan. Because it's so much agency goes on to incorporate therapy, right? the third parties can reasonably believe that this man has the authority, power to act on behalf of the company, then company should take the responsibility and that. You don't need to be a proper appointment or whatever, right? If someone person, maybe second, maybe someone, if you can believe that he has authority, then the company is done. So, likewise in this case, right? So probably bank can reasonably believe that. Generally, what do you think? Who has the power to enter the trading contract on behalf of the company? Generally, directors have a power authority to enter the contract on behalf of the company. It is implied. Is it abnormal? To enter the contract by directors on behalf of a company, is it abnormal? No, it's very much normal, ordinary thing, right? If that amount is abnormally high, you know that is not real, but this is a very much of normal startup. Because someone needs a pulse video, and that's normal. Corporate value abnormal. Because someone normal business hours for the someone. So generally, almost all that of the company is done by the board of directors. There's nothing wrong with that. There's nothing abnormal, right? So therefore, it is generally believed that directors have an implied authority to act on behalf of the company. Therefore, directors enter the contract on behalf of the company, definitely company is fine, right? Because directors have an implied authority to act on behalf of the company. Any general man, any general person can believe directors can represent the company. If you is represented by someone else, maybe secretary or the CEO, then there may be some issues. But if directors represent the company, definitely they have an authority. Right? So in this case, the question was the passing of audit resolution. He can be passed at the directors law. That's the definitely level. Any person not from the bank, any person can leave that directors have authority. The question was whether they have passed a audit resolution. They don't know. Generally, audit resolutions are internal matters. Right? It's an internal requirement. No one filed audit resolution with the registrar general. It is not a public document. Special resolution is a public document. It is filed with the registrar general of government. But audit resolutions are very much of internal regulation rules. Right? They don't file with the registrar. They are not available for the general public. They are not public documents. Right? They are internal matters. Audit resolution are passed in internal matter. Special resolution are filed with the registrar general. Audit resolution is filed with, right? In this case, court was of the opinion that as a third party, you can reasonably believe that the company has complied with their internal proceedings. Right? You can reasonably believe. But if you knew that it was not done, then there's something else. But here you don't know if it's done or not, but you have a reasonable expectation that the company complied with their internal proceedings. So it was known as indoor management rule. Okay. So anyone can believe the internal procedure of the company was smoothly went on. So it was known as the indoor management rule because they were not public documents. What is important is whether directors can borrow money. That is important. Right? So articles at that time, legal settlement says they have authority to enter into contract to borrow money. There's no restriction to borrow money. Right? So it was authorized. So that's the most important. So how to do is internal proceeding. Right? So the third party like that can reasonably believe they have complied with those internal proceedings. Right? Personally, we borrow from money borrow authority. It is like a value marker. But there's a procedure to follow. That internal matters they have to comply with, and we can reasonably believe that they have properly done. It is known as the indoor management. The doctrine of otherwise is abolition, but this is being done. Right? So we can believe that they comply with the internal proceeding. Right? So this is known as indoor management role. Section. A person dealing with the corporation has no obligation to ensure that the corporation has gone through any procedures required by its articles, bylaws, resolutions, contract or policies to authorize a transaction or to give authority to a person purported to act on behalf of the corporation. Right? So they can reasonably believe that internal matters are properly done. By those regulation rules, they are like never don't but we do like that in Srilanka. But even though it is not done, it still compels back. So this is known as indoor management program. Very internal matters come in. Otherwise, external matter. Object was external matter. They are internal matters. Here the question was, the issue before the court was whether the bank was required to determine whether the general resolution of the company had actually been adopted. That was the question. Next, whether the bank want to make sure that internal matter that resolution was adopted. Right? Remember, you got to get dealing with these corporations are not dealing with the like individuals or partners. Right? Individual partner it's different from the dealing with the corporation. Parties dealing with them are bound to read the statutes and the deed of settlement. So when you bank deal with them, you are bound to read the Companies Act and the Articles of Association. Right? Statute and the Articles of Association or Memorandum of Association. But they are not bound to do more. They are not bound to do more. Right? And the party here, on reading the deed of settlement, would find not the prohibition from borrowing money, but permission to do so on certain conditions. Find that the authority might be made complete by a resolution, right? So he was have a right to infer the fact of resolution. It is done. So they are not bound to do more, right? They are only bound to check whether it is authorized to take the articles, memorandum. So that's it. Right? And the other is that laws we have to comply. But by laws, rules, regulations, they are not laws. Right? So they are, we only follow the law in the proper documents like laws parliament, passed by the parliament, or sometimes articles of association. But we are not bound to take each and every resolution document passed by the company. Right? Sometimes even they don't give it. Right? So we are not bound to do it. So we have a right to reasonably believe that they are properly done. So articles, bylaws, so articles, especially memorandum is a public document, right? Others are not public document. Space resolution is a public document. Audit resolution is not a public document. Therefore, they are not readily available for the general public. However, there are some exceptions. Right? These are your doubts for right? Right? two policy reasons in support of the indoor management program. These are the policy reasons to support this indoor management program. It would be an unfair imposition on the outsider who has no right to demand proof by the directors that the requirement of the article of incorporation or bylaws have been fulfilled. You have no right. They are not available. The constant duty to verification would impose an impractical burden on business. So, that makes impractical burden on business. Right? If all the main documents are there, then you can go ahead. Right? So these are exceptions. I think that makes your mind clear, right? So the rule will not apply where the person dealing with the corporation has actual knowledge of the deficiency in the authority of, right? So if the bank knew that there was a requirement to pass the resolution which is not done, then this will not happen. Then bank is not passed, right? Then the directors are not liable, not companies liable, right? If the bank knew that there was a requirement to pass the resolution, it is not done, right? In such a case, company is not liable, hopefully, to directors are liable. Or the rule will also not apply in suspicious circumstances, right? If there's a suspicious circumstance, so maybe abnormal amount, right? Maybe it was asked on holidays, right? So whatever, if there's a suspicious circumstances, then this rule will not apply. If it is done during the normal business hours, during normal business, a normal amount, right? Then the bank can reasonably believe as there's no restriction on borrowing money, they have complied with their internal matters. So it is known as the business, indoor management book. Indoor management. However, I think Sri Lanka is a very good country where we never will face those type of occasions. Sri Lanka, right? They are perfect in that sense. So what do? When we deal with the companies, when they borrow money, our bankers take at least 3 resolutions. When the solutions are not too much, they are not too much, right? Generally, if it is signed by the directors, there's nothing wrong. It is already done. The company is liable. But our banks, they will still ask the company, right? After the solution that the company has decided to borrow this amount of money. Right? That's the one resolution out there. That's good. Right? You should have not make transaction in the company authorized to like a resolution pass. Then they will ask again. So and so directors or whoever are hereby authorized to sign that document or any related other agreement or document. If it is signed by the directors, there's nothing wrong. But still our banks will take that resolution. So it's good. Right? Then no one can say that they are not directors and so and so. Half of them are regular directors and someone transfer back to Form 1. That is nothing to do with the Form 1. Form 1 says about the initial director. Another ignores that. Someone went to Form 1. So that is the initial directors of the front load. They will be acting. Okay, people would like to have a Form 1 in the Form 1 in the directors. Initial director. Only Form 15. ඒ කරුගානේ annual return එක දාපුවාට update. හැබැයි ඊට පස්සේ විසල් දෙන්නත් පුළුවන්. right. නුඹගානේ බැංකු කාර්යය යන්න form 15 එක. ඒතකොට at least it is updated to the annual return date and at least it says that company was properly running. Annual return file කරනවා කියන්නේ. නමුත් සමහරවිට ඉන්නේ අනවශ්‍ය document. ඒ වගේම මොකද කියන්නේ form 1 වලින් ඕක කියන්නේ right. Therefore the best thing is to ask for a resolution. Right. If the company pass a resolution, so it's a very good document. It says they are still directors, they are authorized to sign those documents. And some banks again asked another resolution saying that this is not prohibited by the company's articles and this is within the power of the company. So we do not put a no, I compare for him not be the we not put down. So that's somehow then came more I don't like Lanka, let I there and get the case. Right? Company secretary back as a Malik England order to the learning fella, feel guys, let I get. That is also like our cinema because it has to be passed by the company, right? You can tell me whatever the message you want. That will be signed and drafted by the company secretary. But our banks are very smart and that is really good because they have protected themselves into the fullest capacity they can. The best thing when you deal with the company is to get the copy of the resolution. The resolution should say that company hereby resolved that the company will enter into this type of transaction. Whether to borrow money, or to buy a land, or to buy lease a vehicle, or whatever that should be. Then it should say these two directors, so these two people are authorized to sign the first agreement or any related document related to that transaction. Then they have a capacity, no one can deny. And also, you have another statement. There's no restriction to the company's articles entering into that type of thing. Then that's what we got. So then no one can deny it. So companies will be denied. However, according to the law, if directors sign agreement on behalf of the company, this will be the company's law. But no one can deny it. According to the principles of company law and also according to the principles of alien law, companies liable for the act done by the board of directors. Only in case someone be whether they are board members. The resolution line is not like a housing, right? Board of directors are the level of government, they may be signing on the previous day. When you have a resolution, then it's specified that they are directors of the company. Right. So that is the articles of association. Articles of association. So under that topic, you can yes, you better to have a copy of the section 13 and section 17 in your notes and have a good understanding about the section 17. Right? So what is important is again, so companies now only have one lengthy document called articles of association. Right? Even to simplify this requirement, Act provides you the model article. As it is very nicely drafted, you can have model articles as a articles of your limited company. However, if a company is a guarantee company with any other type of company, then you cannot get this model article. Then you have to draft the set of articles. Even for the limited companies, you have option to adapt the model articles or to have or draft your own article. So anyway, article of association is a must requirement to incorporate a company, which is regarded as very important document of a company because it says not only the internal matters, today it also includes the object of the company. So there's no limit or whatever that you should include these things in the articles, you can include anything, right? But they have to comply with the main requirement of the Companies Act. So some companies they have object clause, some companies they don't have object. So that depends, right? You can draft it as to this because of the requirement or the tax reason or some other things to include the object clause, or you have to figure not to include the object clause. But there are some companies like guarantee company or companies come through BOI. So the law requires that there must be an object clause. So when there's object clause, it is always advisable to act within the object clause. However, even if the company act outside the object clause, still they are not void contract. Today they are also considered as a very good contract. However, the directors may be liable if they have not acted according to the requirement of the company act. And also, shareholders have given right to challenge such contract before they completed against the company. And then indoor management rule. So related to the internal matters, as a third party, bank status of any of us can within the company comply with the internal procedures. We are not bound to check the internal procedures of the company. But it is always advisable to get the copy of the resolution when you deal with the company to minimize that type of issue. Okay. So those are the things related to the object clause and the articles of association. Right. Right. If you want, you can just take 5 minutes and check some of the articles of association available on that. But if you have one more other thing, and you can check them on that dialogue RCI I take it in online. Object clause dialogue. You can check an articles of association. So they are public documents. They are filed with the Registrar General of Company. Can you alter the articles of association once filed? Yes, you can. How to do it? Passing board resolution. Can you change all the articles by passing board resolution? Special resolution, right? Take a board resolution, right? So companies affairs are divided between two, between board of directors and the shareholder. Right? Some of the powers are given to the shareholder. That is also to strike a balance. I mean, no board resolution give like it is the main board resolution. Major transaction and board resolution. Now we are studying board resolution. After studying board resolution, right? So to change the articles of association, companies are required to pass a special resolution. That means we have to inform to the shareholders prior to 15 days of passing special resolution and 75% shareholders have to approve. Then they can get that answer. Because 75% shareholders. Yeah, you will. Because as you increase the requirement, they are not liable by the amendment. So you will see that what is in there, right? So maybe your bill clause is there, right? How to appoint directors, their powers, how to pass resolutions, what is the minimum number of members, forum, right? How to conduct meetings, one and three. Yeah, object clause are clear on the work. Don't say this part. Command I this part. Your kiss my Buddha Kazaka family, it is a sort of culture. It does not done. It does not done. Object was a down. You will say, one ain't no more than a month. We were more than Lanka of Conga. Right? They get only this part. Means you can cut down and space for Buddha. And that's not only the I'll get you that. But actually, even actually, if I do it, and that can person then, whatever contract company, good, very good. So, another point, I in the law, main object, don't use it, things right? Hey, I'm telling you, contract But then we then you must be another compared to the foreign capacity to increase it. And for the landing, and the other table doesn't. And something on the somewhere, so we can make some target. Take it over, then we'll go and change that, which is good. Other than that, when I come up on an unless we have fact that there is no answer. Galle company option करना था मैं private school करना था private university करना अनिवार्य था इधर तो इसको संशोधन है private university करना मतलब private higher education है वो बहुत था requirement है private school लगता था एक object है इधर के कुछ और बहुत था number interest so they are discussing we have that when you want to incorporate the company, don't worry. If you supply the similar company, you can simply adapt the model. So then you can sign it and then you can incorporate the company. Just in case you want to change it, then you can amend that. The model is best properly drafted. Very careful with properly drafted. This says how to apply how to remove them, how to conduct meetings, votings. Right. There's another small topic. Shall we discuss that one, Nasir? Yeah. 450. This is small topic. Correct. Promoters and pre-incorporation countrymen. So now we have discussed about the incorporation section 4, 5. Then the company name 6 to 12. Then incorporation 13, 17. Now from pre-incorporation contract section 23, 24, 20. Promoters, I don't need to discuss much about the promoters. Nowadays, there's no such a role for the promoters for the company. Traditionally, they are now they are almost such an important role because it has become such a simple thing. You all can incorporate company. But we will just go through some slides. So I'm going to skip some slides here anyway because they are not that much important. So, promoter. Have you heard that term before? Promoter. It's not a legal term. Law dictionary, I don't think that you will find the term promoter. It's a business term. Even in the Concurrence Act, there's no definition or interpretation for the term promoter. In fact, there is only one section which says about just use the term promoter. Even that meaning is limited to that section only. So who are the promoters of a company? As there's no definition or interpretation by the Companies Act, then definitely we have to look at the case. How judges interpret the term promoter. According to the cases, we can summarize the term promoter to mean a person who takes all the endeavors to form a company and set it forth. Can be defined as a promoter. The person who takes all the necessary steps to form a company and set it going can be defined as a promoter. In that sense, clearly, there are some involvement of professions to incorporate a company, form a company. So they are not promoters, right? Because they only involve as a capacity of their profession as a lawyer, accountant, auditor. You can be a part of the forming a company, but you only do as a capacity of a profession. Right? So they don't become the promoter. So promoters are the people who get the company incorporated and set it going. In practically almost it is the promoters who become board members finally. That promoters become directors of the company. So if a company is a person, we always compare the company with a natural person. So promoters are the parent of this person. They are the parent of this person. So many try to compare the promoters as agents. In fact, the role, duties, responsibilities of promoters are almost similar to the role of an agent. However, according to some principles of agency law, there are some technical issues where promoters cannot be treated as agents. Right? The technical issue is, the company becomes a person from the date of incorporation. Before incorporation, it is not a legal person. There's no such a corporate entity before incorporation. But promoters act on behalf of a company which is to be incorporated, not yet incorporated. Therefore, there's no existing person. So therefore, according to the lawyers, judges, there cannot be an agent for non-existing people. Right? The Karanda Yana incorporate company agent because there's no existing principle. Company becomes principal or legal person from the date of incorporation. Therefore, according to the technical issues of agency law, there cannot be an agent for non-existing principal. So that is why law don't treat promoters as an agent. But their role is almost similar to a role of an agent. So they are more similar to a role of a parent. Because if the company is a man or human or person, so there must be a parent. So promoters are the parents of this company. So with the promoters, the main question in the business world is that, yes, the company, before incorporation, companies have to enter into contract. Right? It is obvious that even before incorporation, companies have to enter into the contract. As a very simple example, at least company have to enter the contract with the lawyer to get it incorporated. Right? Obviously, a company incorporated the lawyer can carry contract at the hand. Right? So therefore, companies definitely have to enter the contract before incorporation. In many companies, not only with the lawyers, they have to sometimes buy land. They have to hire a second auditor. Right? Auditor, at least you can appoint later, but we have to have a second. Right? You have to have a registered office. For that, you have to buy land, or at least you have to issue the lease. Likewise, employment contract. Right? So it is obvious that companies have to enter the contract before incorporation. But before incorporation, there's no legal person. Therefore, basically, those contracts are entered into by promoters. Those contracts are basically entered into by promoters. So when promoters enter into the contract, so there are issues. What is their role? So they can be treated as agent because there's no existing principle. Right? So therefore, law believes the relationship between the company and the promoters is a fiduciary relationship which depend on trust and confidence. So they are like parents. Therefore, under this fiduciary relationship, promoters are under the duty, especially duty identified by an agent. And because there are two main duties, as you all know, they have a duty to disclose. Because this is even though we say parent or whatever, this is a business office. Right? Promoter is a business office. So they deal with maybe millions of rupees or pounds sometimes. As an example, if there's a person who wants to start a hotel in Sri Lanka, sometimes on behalf of them, this man has to buy a land or island. You never know the land. Right? So those are done by the promoter. Right? Therefore, they are under the duty to disclose all the time. And also, they are under the duty to not to make secret profit. It doesn't mean that they cannot make profit. They can make profit. Even they can buy land with the sole purpose to resold it to the company. But they cannot make secret profit. They are under the duty to disclose. Provided that they can do any business. There was one case, in that case, it's an English case, in fact, it was a phosphate company, where on behalf of this company, a promoter of the company bought a phosphate island. They bought it on behalf of the company. So it was bought for £50,000 and resold to the company for £100,000, making £100,000 profit. Sorry, for 100% profit. The directors were that person who bought that island and his two of his partners. So the papas are the good board. And there were another two directors. They were not in England at that time. Other man was the mayor of Lanka. They got officially in your that. How they make it England? May I marry out the new ticker, make a pass that last year. Thereafter, they transferred their shares. Now they are not in the company. Now company is in the hand of the new shareholder. Then they knew that this promoter has bought the land for 50,000 and resold it to the company for 100,000. And then they filed a case against the promoter for breach of their duty. So they filed a case that they have not acted in good faith and they have not disclosed. However, this man has disclosed the transaction to his two friends. Actually, I have already disclosed Edina figure here in this case, the English court decided promoters are under the duty to disclose all the fact to the independent board of things. They simply cannot disclose it to their enemies or their friends. In this case, in fact, the independent two directors was not even in the England. The court decided it was not the proper disclosure. So disclosure must be a proper disclosure. Proper disclosure means to disclose all the facts of the transaction to the independent board of shares. So in this case, court was of the opinion that it was not disclosed to the independent board. Therefore, court ordered that man to return that 50,000 to the company. Therefore, the promoters are the duty to not to make secret profit and to disclose everything. So, provided that they disclose everything, then they can make profit. So, those are the role of promoters. So, this is the only section that uses the term promoter. Right? So, it says for the civil liability of untrue or false statement in the prospectus, together with other officers, managers, directors, promoters are also liable. Right? That's the only section that uses the term promoter. Right? Every person being a promoter of the company is liable for the untrue statement in the prospectus. Right? Any person can act as a promoter. Right? That's the case that I explained to them. Right? when there's a breach of duties by direct promoters, no, the company has a right to cancel the contract or recover the secret profit, or they can file a case to get damages for breach of their duty. So are they entitled for payment, promoters? Technically, because they are paid. Right? Here Lamai Buddha, and if the 8% they are not paid. Right? However, if the article provides the complaint pass resolution, then there's nothing. Resolution they are not paid. However, who does the article? Promoters. Right? And they become delayed. Therefore, definitely they have process for their payments and expenses. So there is nothing to worry. Right? If the promoters they become directors, the promoters they draft the article, they definitely have process for their payment. At least they have some process that they company issue shares for their expenses. They company issue some share. Yes, generally articles of association come to discussion power upon directors for the preliminary expenses occurred by them. So this is the I want to talk about, right? Company contract, right? So company contract we can divide it widely into two as pre-incorporation contract and after incorporation contract, right? Company contract can be divided into two as pre-incorporation contract and after incorporation contract. So contract after incorporation of company, generally we don't term them as after incorporation contract. They are known as company contract. But contract entered into by the company before incorporation are known as the pre-incorporation contract. Before incorporation, pre-incorporation contract. Contract entered into after incorporation are generally known as the company contract. After incorporation, company contract. Right? Therefore, company contract will be pre-incorporation contract or after incorporation contract. After incorporation contracts are generally termed as company contract. So, law relating to the pre-incorporation contract before 2007 was the common law. According to the common law, before incorporation, no contract, no artificial person, no legal person. Therefore, if entered into by a person on behalf of the company, that person, probably promoters are liable for those terms. That is the agent's law, that's the contract law, that was the company. Right. However, this is not fair against, especially for the third party. Sometimes people buy land, acres and acres, small island, on behalf of the company before they start hotels and so on. Right? If company did not incorporate, sometimes those promoters, they are like, oh, you can't even get away. Right? Therefore, it makes some injustice for the third parties who enter the contract with the promoters on behalf of the company. Right? Therefore, again, first time in Sri Lanka from 2007, now some kind of recognizes that even companies can enter into the contract before it's incorporated. Right? Now, company can even enter the contract before it's incorporated. But I don't know whether our bankers are able to accept it. Right? I don't think they will. But law is there. Company can enter the contract even before it's incorporated. So one case came to me, there was a company. So they want to get a lease agreement until the company gets changed. Company just they get to it, Lanka, I go to a lease agreement. I thought, yes, we will do. But they have to get for the loan but the bank was not there. So therefore, we didn't fix that one, right? Bank company bank ask us for our open opposition on it. Ask us for one come, then relax on the bank professional. But evidently, the law provides that the companies can enter the contract even before import. The company was very updated, right? All things are online, right? So I don't know the business people are happy, but the law is very updated with the company. Right? Therefore, contract entered into before incorporation are known as the pre-incorporation contract. Okay. So according to the common law, pre-incorporation contracts are not recognized. If they do, the promoters are personally liable. As there's no legal status, no legal person, the company is not liable for the contract entered into by person or company before it's incorporated. Right? So this case, Kelly versus Baxter, probably we have discussed it for the agency law, then I'm going to report that. But if there are other kinds of Kelly versus Baxter, this is a case we discussed under the agency law as well as under the company. In this case, Kelly was a vice. Baxter was the promoter of the company, which is to be incorporated. It's not yet incorporated. The company to be incorporated was a restaurant. So, before its incorporation, that's the promoter entered into the contract with the wine seller to buy some wine on behalf of the company, which is to be incorporated. So they bought some wine. Few months later, company was incorporated. Even after incorporation, company continued buying wine from the same person came. However, before they were paid for, company went back. Then the wine seller filed a case against the promoter, Baxter. But Baxter argued that it was not me, it was the company who bought the wine. Therefore, I am not liable to pay, I am only an agent of the company. So the company is liable to pay for the wine. That was his argument. So how agency was created? His argument was company has ratified a contract that he entered into before incorporation. Because even after incorporation, company continued buying wine from the same seller. That means company has impliedly ratified the contract. Therefore, as there is an agency by ratification, company is right. That was his argument. Once contract is ratified, then that can be backdated and it is equal to the original authority. The question was, who was liable? This is again old case. In this case, court decided, even though company has ratified the contract, that ratification was not valid. According to the agency law, to make a valid ratification, there were some requirements. Some requirements are there. Some of them were amal. At the time of contract, there must be a principle. That principle should have a contractual character. Right? So in this case, court decided at the time when he entered the contract, there were no existing principles. Because company was not incorporated. Unincorporated association is not a legal person. Therefore, the English court was of the opinion that there cannot be an agent for non-existing principles. Therefore, court decided that promoter was personally liable. That's the person liable to pay the money. That is still the agency law. Agency law is not a but among some other and you are doing nothing agency by ratification. Right? Agent can principal can keep loan and move contract and ratify the reasonable time we can ratify the make it personally, contract principal can keep it. So, penny incorporate You cannot promote a personal land. So, however, even though this is still the agency law, this is not the company law anymore in Sri Lanka. Right? If a promoter acts on behalf of a company which is to be incorporated, then there's no application of Kenya versus that's the case in Sri Lanka anymore. It is modified now by the statutory law by the company's action. Make it company cannot ratify the contract. Contract entered into before incorporation cannot be ratified. Even though ratified, it is not valid. Because there were no existing principle ratified, but that ratified so this law was, yes, the case we got if you want, decided in 1866, but now it is modified. Right. So this is the new company law. You can see section 23. This about the pre-incorporation contract. What is pre-incorporation means? Name suggests name. Pre-incorporation. Before incorporation. Before incorporation. Section 23 defines what is a pre-incorporation contract. So I'm the pre-incorporation contract. That's a very clear three sections come up, right? Section 23, 24, and 25. First, this says pre-incorporation contract is a contract purported to have been entered into by the company before its incorporation, or a contract entered into by a person on behalf of the company before its incorporation. Therefore, if a contract is entered into by a person or by a company before its incorporation, is a pre-incorporation contract. So that's the environment pre-incorporation contract. The very actually you must have again. You can see two again. Notwithstanding anything contrary to any law, pre-incorporation contract may be ratified. Right. But the China versus custody cannot ratify the pre-incorporation contract. Even though ratified, ratification was not done. Like section 23 notwithstanding anything contrary to any law, pre-incorporation contract may be ratified. We can look at the notwithstanding case. Monolithic monarchy, actually, can agency over the monarchy, company over the full agency over the monarchy, well over monarchy, company over the pre-incorporation contract may be ratified. Back over the monarchy, contract over the monarchy, agency over the monarchy, company over the full the game to protect the third party. Acting as third party protect the other party. Right? So, pre-incorporation contract may be ratified. Then by section 24, it also introduced two implied warranties. Two implied warranties. Right? You can introduce condition warranties by law. Sale of goods down. There are implied condition warranties implied by the sale of goods volume. That the seller should have a right to sell. Right? Goods should be of marketable quality. Goods should fit for the buyer's purpose. Right? So, implied warranties condition introduced by the sale of goods law. Likewise, in companies that it introduces two implied warranties by Section 20. First implied warranty is that the company will be incorporated. The company will be incorporated within the time set, or if there's no stipulated time, within a reasonable time. Unlike that, here in Kaya, company incorporation. Then the company will ratify the contract, enter into the full incorporation within the time set, if there's no set time within the reasonable time. In our contract, contract, incorporate contract, ratify. Export years in the college, Nakan Sada, it was a thorough here, Section 25 says, if company fails to ratify, failure to ratify, then what court can do? Section 25 is incorporate ratify, then court can direct the company to return the property back to the original part. Right? If there's a property acquired under the pre-incorporation contract, but company has not ratified such a contract, then court can order against the company to return that property back to the original part. But the third party is protected of the company incorporate island company incorporate right? The court can order the company to return that property acquired under the pre-incorporation contract back to the original part, or to validate the contract in whole or in part. You know, something of a contract. Company or to grant any other relief in favor of that other party, not in favor of the company. Right? To grant any other relief in favor of that other party. Right? One moment you can enter the contract with the company without any doubt, even before it's incorporated. It must not be one compare. Court will order to give it back to you. So very good cost, very updated. I don't know whether our banks or other people are happy to accept it. But law is totally very good. Maybe compare with very all other laws. Finally, compare incorporate government contract. By the government law in capital kind of after people sign the program, what will I be right? A very right? Usan government is not a supporting opposite. Nothing you can tell you, one of the contract. Not to the other. So those are good for the business people. Right? Right. Now, the company can certify it, or company can use the new agreement, or promoter is still longer. Or not, promoter will go down, it's still pull on a side. Then will take up right? Even once incorporated, company into the new contract with the incorporated company and other part. Take up the right? Apart from that, now company is also live. Before 2007, company never was live. Now company can also live. Because the pre-incorporation contract may be certified. That is that's for law, the deviate from the common law can back, right? English law can back, agency law can back. But company law says when the promoter is act on behalf of a company, that contract can be ratified, even though there is no companies incorporated. The ratified pre-incorporation contract should be valid and enforceable as is the normal contract. Right? The ratified contract, normal contract, right? Right. Now, after incorporation contract, that leads you to the company contract. How company can use the contract? Company has application only. For the contract, the CEMP, you know. So the company contract, they are imposed. You require it. Someone can put a achieve. When we appeal to someone in field, on the campus to go there, on the level, basically we have a seat in the give the free ticket. We cancel it. They are doing it. Not on private. So they go back to Mars. Here again, it was the marketing and one of the they don't trust the people. They have to detect the trust the base because single channel after. They were getting Hadi as I see to the local see the Ganata, either see the Dam in the Pilla, after next. Nagar Sada is nothing. I mean, with the Assam, because we take a regular, take a field at the money. Assam come upon the field. That's of my grandkids, the after the Mandala, another altogether. The Manga on the come. That was repair the same I see the couple of dialects. They also look at it. We are constantly and see the name. So, I am not going to get okay. Yes. So, that's school on the principal again. Right? He's taking to run the turbulent action at the other end. I mean, you should come in the field for a good way. Field data to be a fancy done. When it is a garden. Some people that will never power of and we lost the data. Unless they have online technical, they can check it. Right? Make a technical then you have to facilities still the best. Become a factor and go Lanka still. Online field. Right? Someone got only together. Ekatarian and Liga, how you take a seat that only together. We never take a government. It was in the Handigan minute, will be at the Handi, they will see that. Who mock the other. Our people don't trust us. They trust in it. Some other knowledge that we would like to take the gun from the air, how both of them 19. Then we also mutual deal in passport to the piano or among the passport to fit for the appear that they just give it and then we leave the thing is that our killer is there, we are killer is can never get it. Have I indicated about Bulu, Mr. Singh, and I can come of political on it. Well, this is not for 2 hours, we have been piano. If we feel the whole time the lazy, this is on the back. We are able to calm trust and see the area, how we can use it. We will get a birth certificate. One put the birth certificate. Masa power no Tareka. Masa power no Tareka. Mock to me, I will not done. The birth certificate of the national. If it is not clear, then you can ask it. නෑ උන්ට අතන ගහන්න ඕන දෙයක් කරනවා කියන්නේ නැත්නම් ඒක වෙනස් වෙන දෙයක් නෙවෙයි ඒක ක්ලියර් නැත්නම් අලුත් එකක් ගන්න කියන එක වෙන දෙයක් නේද දැන් ඊට පෙර යමන මොකද පොළ නැති ඉඳලා ඒක වෙනස් දැන් පොළ නැතිනම් ඒක ඕකේ right දැන් මේක ඇක්ටිව් කරලා මාත් කොහොමද ළමයි පොළ ළමයි කොච්චර දේවල් කරනවද නේ ඉතින් දෙවියන් මොකක්ද කියන්නේ අපිට ඉන්නේ ඉතින් පොළ ඉන්නේ පස්සේ නෝදා දැන් ඔබ ආපහුම පොළ නැති ඉඳලා වෙනස් කරනවා ඔය වගේ ස්ත්‍රී ළමයි මම වීඩියෝ ෂෙයාර් කරන්න ගන්න නේ Because we are used to use their trust. They don't work and work together. So even though some of newer generation people still work for the company, the people who dropped the companies Act in 2007 was aware that there's nothing to do with the company. So therefore, it can also be option. Right? Consent company scheme was considered as a 3% company and two directors signed as a witness to the company enforced fee. Company enforced fee 3% the company. It was in the hand of the company secretary. However, that mandate requirement was also done away. Now it is not mandated to have a company seal to enter into the various company. Therefore, don't ask your client to have a company seal. It is not mandatory. Right? Section 19 is about the company contract. There's no requirement of embossed fee at all. Also, they company contract must be affixed to the company and two directors must sign as a witness to the